We're now looking at employment conditions. We're looking at the conditions of your employment. We're looking at how you can be dismissed from your employment, the rights and responsibilities you have as a worker. Okay, there's a whole heap of stuff we look at in employment conditions. This is a really content-heavy section, and so I've got a few different documents. I might as well go to my next slide now. I've got, if you've seen the do section, I've got a anti-discrimination legislation FREYA model. I'd really like you to, when we're going through the EEO and anti-discrimination legislation, I'd like you to write your notes into that document as we're going so that you've got a good summary there. And then I've also got a why model document on the different types of employments. Again, when we go through that, please write your notes as you're going. So you've got some really succinct notes on this part of the unit. You need to know the varying types of employment that exist and the legislation related to your employment when you're employed in Australia. And you need to know the rights and responsibilities of a worker and the rights and responsibilities you need to provide to your workers if you're an employer. You also need to understand the reasons why you might actually be dismissed from a job. So the sorts of things that can get you in trouble and dismissed for or fired for your work. And lastly, you can see the two do's there. I've already spoken about the two different graphic organizers, but then I've also got a past HC question that I'm going to get you to respond to. Write it down, written in a book, on paper, with a pen, handwritten, take a photo of it and submit it up on Google Classroom. And that's really specifically around the Anti-Discrimination Act and its purpose. So keep those things in mind as we're working through these slides. We'll get started. There are four main types of employment. We talk about full-time employment, we talk about part-time employment, casual, and contract. Full-time and part-time I'm going to describe in the same way. A full-time employee gets all of the exact same benefits as a part-time employee. The only difference is how much they work and the percentage they're owed. So a full-time worker works 100% of a full-time week, whereas a part-time worker works a different percentage. Maybe they work 2 days a week instead of 5 days a week. Because they work 2 days a week instead of 5 days a week, they only get that percentage of all of the benefits of a full-time worker. So we'll run through it. A full-time worker works approximately 40 hours a week. We know that in carpentry and joinery, a full-time worker is actually working around about 44 hours per week, usually split across 5 days, which means they have 2 days off. That's their weekend. Sometimes your weekend is Saturday, Sunday. Sometimes your weekend might be Sunday, Monday. Okay? Your weekend are just the 2 days that you have off. Sometimes you'll work overtime as well. Okay? But a full-time worker works approximately 40 hours a week, approximately 5 days a week. And when we talk about a full-time worker, they get a salary. Okay? Their salary is a total amount of money that they make in a year. They also get annual leave. So you get 4 weeks of annual leave in Australia when you're a full-time worker. And that's 4 weeks where you get paid your normal wage, okay, your normal 5 day a week money, and you don't have to go to work. That's what annual leave is. Okay. In addition to your annual leave, you also get sick leave. So your sick leave then is actually leave that you use when you're sick. It means that you still get paid, but you don't have to go to work. And most different organizations give you approximately 10 sick days per year, and if you need to use one of those, you get a doctor's certificate to show to your boss to prove that you were actually sick and thus deserve to be paid. Okay, now, if you run out of sick days, you don't get paid for not being at work anymore. So you only have the sick days that are available to you, and they usually add up. So if I've worked for a company for 10 years and I get 10 days per year, then at the end of my 10 years, I'm going to have about 100 sick days available to use. The same works with your annual leave. If I get 4 weeks of leave each year and I haven't taken any leave for 5 years, then I have 4 weeks of leave times 5. Therefore, I have 20 weeks of annual leave that I can use. Okay? Now, there are lots of companies that close down over Christmas and they force you to use your annual leave during that break. Okay? They might use 2 of your weeks, and so you only get 2 weeks to use on your own. Full-time employee, that's their benefits. Part-time employee, a little bit different. Okay, they still get annual leave, they still get sick leave, but they just get a percentage of it. Okay, it's what we call pro rata. You get what you work. You still have a salary, you still have an annual leave amount, you still have a sick leave, and your hourly rate is the same as a full-time worker. You get paid the same per hour as a full-time worker. So that's the first two. Then we have casual. Casual is someone that gets paid by the hour. They don't have a full-time job. They don't get annual leave. They don't get sick leave. And to compensate them for that, they get paid a little bit more, what we call casual loading. So if a full-timer earns $20 per hour, a casual might earn $21 per hour. And that extra $1 an hour is equivalent to the amount of money that would normally be put aside by a company to pay for their annual leave or to pay for their sick leave. Okay? Now the problem with casuals, there's no job security. Okay? There is absolutely no job security. One day you might have a job, and then the next day they might not need you anymore, so they stop paying you. Whereas the benefit with part-time or full-time employees is that your job is secured and it is ongoing until you are either fired or you leave or the company makes you redundant. So that's casual. And then we have contract employees. Now, contract employees are people that only work for a short period of time. They can be part-time or full-time, but they're only being given their job, not permanently, but they're being given their job for a short period of time. For example, I might put someone on a contract to work over summer holidays to do all my digging for me because I don't like digging in the hot weather. Okay, so I would pay them on a contract and I would say, you have this much money, I'm going to pay you 5 days a week, 40 hours a week from the start of December to the end of February. Okay, contract, at the end of the contract, they don't have a job anymore. So there we go, a bit of a summary in the different types of employment, and we can go into that in a lot more detail if you want to discuss that. If you've got any questions about employment you might have. We then have this area here on awards, agreements, and contracts. Now, when you are employed by a company, there are minimum amounts that they can pay you, and there are minimum conditions of your employment that you must be given. For example, if we think of an award, the award is the top level. It is the very basic conditions of employment and minimum amounts of pay that anyone can be paid in any industry in Australia. There is an award for each industry. So there is a construction workers award. And if you work in the construction industry, it outlines the minimum amount that you can get paid and the minimum conditions of your employment. Awards are the minimums. They are set by the government and the Fair Work Commission in consultation with industry. Next over, we have agreements. Agreements also set out minimum conditions, but they can be higher than the award. So if you work in the construction industry, you might get paid what the award says you are owed. But if you work under an agreement with a specific company in an enterprise agreement, they can actually choose to pay you more. Now, why would they choose to pay you more? Well, because they want to keep you in their company and stop you from going to other companies. So that's why they might increase the amount of money that they think you're owed. Okay? You can't just make an agreement with your boss and be happy with it. That would be a contract. I'll get to that in a minute. An agreement is a formal document that is written out by a company and their legal team. They send it to the Fair Work Commission, where it gets checked by that government department. And following that, if it meets their requirements and it still meets the minimum conditions of the award, it will get registered. Once it is registered, it is valid and able to be used for how you are paid. The third option we then have are contracts. Contracts, like I mentioned to you in the previous slide, are where it's a set of terms and conditions of employment specifically between one person and their boss. A contract can be written or verbal. Usually they're written down though, okay, to help you in a legal battle. And Again, your contracts must meet the minimum conditions of the award, but they can be higher. And they usually come with additional terms and conditions. Now, for example, they might choose when they hire you to put you on a contract and pay you a whole heap of money. They might pay you $100,000, for example, the dream amount of money. But they might say something like, oh, you're not allowed to work for any other companies in the construction industry for 2 years if you resign from this job. So the contract can actually put restrictions on you as an individual and the things you can and can't do as an employee. Okay? Remember though, for both agreements and contracts, you can never be paid less than the minimum amount that is listed in the award. Now, when we talk about the terms and conditions of employment, we talk about the Fair Work Information Statement. This is 10 rules or 10 employment standards that the Fair Work Commission have outlined for all workers in Australia. It contains your right to annual leave, your right to sick leave, your right to a safe place to work are all included here in the National Employment Standards. And if you just click on this link, you'll see that it opens up. Okay, a little PowerPoint for you. Bear with me just a minute while I open it up. Okay. The employment standards are your right to annual leave, your right to personal leave, carers leave, compassionate leave, family and domestic violence leave, jury duty leave, okay, or community service leave as they call it, long service leave, parental leave, a minimum amount of hours per week, and a maximum amount of hours per week, your rights in public holidays, your rights when you are terminated, and your rights to redundancy. These are the 10 minimum national employment standards that exist for a worker in Australia. You also need to know what happens when you breach these terms and conditions. And if you breach terms and conditions of your contract, you can be fired, okay? Or you could be subject to workplace disciplinary action where you get in trouble from your boss, a warning against your name. You could also be required to do additional training if you breach your terms and conditions of your employment. Now, the last thing I'm going to mention here in terms of the employment terms and conditions is the award. We are, as building and construction workers, going to be employed under this award here, the Building and Construction General On-Site Award 2010. If you go to this document, it outlines exactly how much you get paid for your qualification level and all of those minimum sets of working conditions that exist for your job specifically. Now, I'm obviously a teacher, so I'm covered by a different award, okay? But if we were to go and work in the construction industry, that is how we would get paid. So this is where we now get to your rights and responsibilities as an individual worker. Firstly, you have the right to be protected from discrimination and sexual harassment in the workplace. You have the right to feel safe at work. You have the right to be represented by a union, okay, what we call union representation, which means if you don't feel confident or are not sure about your legal rights, you can actually, if you're a part of a union, you can ask the union to represent you in any issues relating to your employment. Coming with those rights, though, are your responsibilities. And you have the responsibility to know the terms and conditions of your employment. You have the responsibility to obey any instruction that your boss gives you, as long as it's lawful. Okay? You obviously don't break the law for your boss, but they ask you to do something that's reasonable. You're expected to do it. You're expected to maintain confidentiality. We've spoken about that in the previous set of slides, okay, around workplace, client, and colleague information. You're expected to attend your work and to attend it punctually. Part of the employment terms and conditions comes down to codes of conduct. Lots of companies build codes of conduct. Okay, these are rules that outlines how you should behave, okay, as an individual or as a company the proper practices that you must follow. Now, the Master Builders Association has a whole code of ethics on the sorts of things that you need to do if you are going to be a worker and be part of the Master Builders Association as well. Okay? Some of those things include making sure that you are being confidential in your managing of data, that you're being honest with your clients, okay, regarding the cost of things, the timeline of things, that you're building things to the best of your ability, and that you're complying with all of the regulations and standards that exist for our industry. So we'll now talk about some of the legislation. The first bit of legislation that we want to know is the Equal Employment Opportunity Act, the EEO, Equal Employment Opportunity Act of 1987. This is federal legislation, which means it covers all of Australia. This law says that it is against the law if you discriminate against people. Okay? It overlaps very closely with another bit of legislation that we're going to learn about, the Anti-Discrimination Act. It's saying really specifically that discrimination is unlawful when it's got something to do with your employment, including recruitment and termination in your employment. So you can't hire someone because of race, religion, sex, etc. You also can't not hire them because of their race or religion or gender or whatever it might be. Likewise, you can't just fire someone because of their gender, or fire someone because of their race or their religious beliefs. Okay? Because of the Equal Employment Opportunity Act 1987, those sorts of scenarios are illegal. The Equal Opportunity Act covers things like reciprocal rights. You have the right not to be discriminated against, but you also have the right not to discriminate against anyone. So if you're an employee, someone who works for a company, you should feel safe and you shouldn't be discriminated against, but at the same time, you are not allowed to discriminate against other people. That's what we mean by reciprocal rights. The same rights exist for workers that are managers or bosses in companies, so those employers. You have the right not to be discriminated against, but you also have the responsibility not to discriminate against others. So we then link into the New South Wales specific legislation. So if EEO was federal legislation, then the Anti-Discrimination Act 1977 is the New South Wales version of that. And it's really specific, and there's some examples that I've got up here for you on things that you can't do towards your employees. You cannot treat job applicants or employees unfairly or harass them based on age, disability, sexuality, marital status, race, gender, transgender, any of those sorts of things. It is illegal to harass someone or not treat people equally because of those. It's also against the law to treat their relatives, their friends, their colleagues unfairly or harass them if they associate with someone of age, disability, marital status, etc. So those reciprocal rights, you shouldn't be discriminated against, but you also shouldn't discriminate. And everything to do with employment should be what we call merit-based. Employers, managers and supervisors, when we are looking to hire people, have a responsibility to treat all of our job applicants and employees on the basis of their individual merits. Okay? Not because of their irrelevant personal characteristics. What that means is we need to make sure that we are finding the best person for the job, not finding just the best person that we like. We need to make sure that our employees also are not harassing other people, and that during recruitment, it's available to everyone, and it's only restricted to people based on merit. So I'm not allowed to advertise a job that's specifically for women or a job specifically for men. That would be illegal under the Anti-Discrimination and the Equal Employment Opportunity Acts. What I can do is advertise a job that says you must have a Certificate 3 in carpentry, because that is merit-based and not based on someone's irrelevant personal characteristics. Once people have their jobs, They should be treated based on their merit. So if they get a pay rise, it should be because of their performance at work, not because of their individual characteristics. They should get training because they need it, not because of their personal characteristics. And they should get promotions because they deserve them, based on their work performance, not because of personal characteristics. We shouldn't be discriminating against people that are pregnant, and that shouldn't play any role in whether we dismiss them, force them to retire, or if we choose them to be redundant. Those sorts of things would be against the law under the Anti-Discrimination Act. Now, there are some procedures around this equal employment opportunity. When you are in a company and you think that someone may have harassed you, or you feel harassed at work, then you follow the grievance procedures. Now, grievance procedures are documented in your workplace agreements or your industry award on exactly what you should do. But effectively, the process is to report up the chain of command. You let your supervisor know if they are the one that's harassing you, or you don't feel confident telling them, or they've done nothing about it. You go to their supervisor and tell them. If you're in a big enough company that has a HR department, you can also report directly to the HR manager. Now, these are internal procedures within the company. If you're working out in a smaller company and you probably don't want to go to your boss because it's the only other employee that's there, then you might want to consider going to an external reporting procedure. This is where you can go to the Anti-Discrimination Board and lodge your complaint. And if they think that your complaint is valid, then they'll put you through a conciliation process. This is where they run a mediation meeting between you and the person who has harassed you. They facilitate that meeting so that they can try and clear the air and get people back working effectively together. If that is unsuccessful, there is the New South Wales Civil and Administrative Tribunal, which is effectively like a court that is able to make determinations on employment and unfair dismissals, harassment, and the like. Now, if you're a boss, anti-discrimination might make it seem like you can't fire any employees. And I guess the underlying principle here is you shouldn't ever want to fire an employee. You should always give them the opportunity to succeed and give them additional training if required. But there are some times when you must dismiss an employee. And some of those examples would include if they are negligent, careless, or cause an accident. So if you have someone that has breached the health and safety laws with regards to their duty of care, causing an accident, or is negligent in their duty, you can dismiss them. Okay? And you don't have to be worried that you've breached any laws. You can dismiss an employee if they've committed a criminal offence, so if they've stolen from you, for example, okay? Or if they've attacked you or harassed you or any other sort of law, okay? You can dismiss them based on that. And you can dismiss them if they are being disloyal, okay? Sharing company secrets, or basically providing important information to the competition that's preventing your company from being successful. So these are some of the things you can do as a boss if you've got workers that are not meeting the rights and responsibilities and expectations of their job. Now, what about if you felt that should be financial penalties for some of the things that have happened? Well, this is where we talk about recourse and the recourse that is available to people. Now, if you have made a complaint to the New South Wales Administrative and Civil Tribunal that you've been discriminated against at work, and you are successful in that, you may be awarded up to $100,000 in damages. That's the maximum in New South Wales that you can be awarded. On the flip side, if you are the company and you're an individual who has fired someone from their job, or you've harassed someone in their job and it was unlawful, there is a penalty for you individually of $12,600. And your company then has to pay a penalty of $63,000. Okay? Just seeing on the slide there, it doesn't say 63,000 as an extra zero. It's definitely $63,000. Okay, so these are some of the financial penalties associated with those laws that we've been speaking through: the Equal Employment Opportunity and the Anti-Discrimination Act. That's the end of today's slide. Like I said, there's a lot of content in there. There's a couple of worksheets I'd like you to complete, as well as an extended response for you to respond to. Thanks very much.